Hello, I'm Advocate Nikita Pandit, and I will be speaking on the infringement of trademarks and its exceptions, and you're watching Legal Bites. The main objective of this video is to understand which acts constitute the violation of the rights in the trademarks and in which cases it will not amount to the violation, that is, the exceptions to the infringement. Infringement is any act of violation of any law or encroaching on someone's rights or privileges. As per the World Intellectual Property Organization, there is primary infringement and there is secondary infringement. Primary infringement is where another person uses the mark which is identical with the trademark which is registered lawfully, and the same is used by that person for the goods or services which are in relation to the goods and services of the registered trademark. This is when it is done in the course of trade in an unauthorized manner without taking the permission of the registered owner of the trademark. Now, in case of secondary infringement, the mark used by that person is so similar or identical with the registered trademark in case of similar or identical goods or services that it may possibly create confusion in the minds of the people that it is somehow associated with the registered trademark. Now, in order to see if there is an infringement, there are certain tests. First is that it is seen if the marks are identical. Identical, which means they are same if compared with each other in all material forms, such as maybe same shape, same color, or the overall look. However, there may be some inferior differences, but it is seen all together if it has the potential to cause the confusion. The mark is compared with the one which is registered and not the one that might be actually in use. For it to be an infringement, another criteria is that the mark should not be distinguishable. The best examples are that of counterfeit goods, which means the goods that are exact imitations of the goods belonging to the registered trademark user, especially when it is done for the fraudulent purposes. It is a rule that any person cannot take the advantage by making small changes to another person's trademark. The Trademark Act of 1999 provides that the owner of the trademark, which is an unregistered trademark, cannot institute the legal proceedings to stop the violation of their trademark use or to recover the damages for such use as per Section 27 of the Act. However, he has the right to initiate the action of passing off goods or services. Let us see what is an infringement of trademark. Only when the trademark is registered with the registry, it gives an exclusive right, that is the sole right, to that person or entity to use that trademark for their goods or services. Section 2 Clause X describes the registered user. It is the one whose name appears in the register of trademark as the registered user, as per Section 49, as we have seen in the previous video. Section 2V provides the definition of the registered trademark proprietor, that is, he is the one whose name appears in the register of trademark as against the registered proprietor. Only the registered trademark proprietor or user can file the infringement proceeding against the person who makes an unauthorized use of their trademark as per Section 28 of the Act. If at all, similar or identical trademarks have two or more registrations, then every trademark owner has exclusive rights separately. They can file an infringement action against all the persons but not against the other registered users. Section 29 of the Act deals with the infringement of trademarks. It is an infringement of trademark when someone uses the trademark of the registered user for making money in course of trade, who himself is not a registered owner of the trademark, and he does not get the consent of the registered user and makes the use of that trademark. Such mark used by that person is either identical or deceptively similar to the registered trademark. Identical means resembling with each other or exactly like each other. Deceptively similar as per Section 2H of the Act means nearly resembling, which may cause confusion or deceive the public that the mark belongs to the registered user of the trademark. The acts of infringement are as follows. The first is when any person who is not a registered proprietor or a user does not acquire the permission from the owner of the trademark, but he uses such mark in his trade in respect of his own goods and services, there may be an identity or similarity between both the marks, so that the person looking at such mark thinks that it belongs to the registered user of the trademark. When because of it being identified as the registered trademark, it is considered that it is bound to cause confusion in public, and any person claiming otherwise has to prove that it will not cause confusion. Second is the case when such unauthorized person does such acts, where even if no confusion is caused, the mark that he uses for the goods or services in trade is identical or similar with the registered trademark, and it is not used for the similar or identical goods or services by him. In such circumstances, the use of the mark by that unauthorized user gives him the monetary advantage and he makes profit from it, or if it maligns the reputation of the registered trademark user or owner. Another case of infringement is when such unauthorized person uses the trade name or its part or a business name in same goods or services for which the trademark is registered. Next is when unauthorized person, as mentioned before, puts such registered trademark of another person on the labels, packing material. He advertises it and uses such mark on the business papers. A trademark is infringed when such unauthorized person advertises such registered trademark which brings him unfair profit because of it being similar or identical with the registered trademark, or if it is harmful for the trademark which is registered and it takes away the distinguishable features of that trademark, or if it is against the reputation of the registered trademark. Usually, the infringing acts include putting the registered trademark by an unauthorized person on the packing of the goods, if he offers such goods in sale, or he stocks it for fraudulent purposes, or offers such services by using the registered trademark as his. He imports or exports from other countries using the registered trademark, or uses such mark on the documents which are associated with the business, such as letterheads, stamps, and likewise, or if he advertises it in any other way, maybe by pamphlets, messages, emails, or in any other manner. Section 30 of the Act provides for the exceptions to the infringement, that is, when the use will not be considered as an infringement. The first is when it is made honestly as a practice of industrial or commercial matter lawfully. It will not amount to infringement. Industrial and commercial property is explained by WIPO as when the signs are used for conveying the information to the purchasers and consumers about the goods and services that the person is offering. It is also not considered as an infringement when the use is made by a person and it does not amount to unfair advantage by making profit out of it. Such use or is very detrimental to the reputation of the trademark owner. Trademark is not considered to be infringed where the mark is such that it shows the kind of goods, quality of goods or services, or quantity. The intended purpose means it indicates for what the goods are to be used. If it is a geographical origin, time, or production, or show the features of that goods or characteristics of the services. When the trademark is registered and there are terms and conditions in that registration, such trademark is used by another person for the goods or services normally, or for exporting these products or services. When the terms and conditions are not broken and the use is made by another person, it is not considered as an infringement. When a person uses the trademark of another person for the goods which are connected to the goods of the registered trademark owner, and such use made by that person as a registered user or proprietor is a permitted use, such as on license or assignment, and such trademark is not removed. The mark from the goods or services is not erased, or if the registered user has consented the use of such mark to another person, in such cases it is not considered as an infringement. Another case is when such use is made by any person with respect to the services where such proprietor or registered user uses the mark in the commercial manner, and such use is a permitted use. When the use is made to show that the services are offered by that registered user or proprietor, it is not an infringement. When some product is an accessory or adapted so that it becomes a part of those goods, then if the person uses the trademark of those goods to show the connection between the two and not for any other reason, it is not considered as an infringement. However, if there is any other purpose involved, such as making profit out of it, and if there is no connection between the two, then it would amount to infringement. When the two trademarks are identical but both are registered, they have equal rights to the exclusive use of the same. It does not amount to infringement. When the trademark rights are transferred to a person lawfully by sale, by assignment or license, and such person or any person authorized by him, if trades the goods in the market using that mark or assigns to someone else or is sold in the market by the transferee himself or by anyone with his consent. However, the transferor can prohibit such further transfer or use if such circumstances is changing the condition or characteristics of those goods. As per section 33 of the Act, the earlier registered user of the trademark cannot file a suit for declaration of any user of the trademark as an invalid use or oppose such mark if for a continuous period of 5 years he have been aware of such use by another person but does not do anything in those 5 years. He cannot just after 5 years come and oppose the use by another person. As it is said, law only favors the vigilant. In any case, the later registered user cannot oppose the first registered user. Section 34 also prevents the owner of the trademark to oppose or interfere other registered users of the trademark having the mark which is identical or similar to that of his own, if such other person or his predecessors are using the mark continuously for a long period of time before such owner are using such mark before the registration of the trademark. And when such prior use is proved, the registrar cannot deny the registration to such mark only by the reason that the other mark is registered. So these are certain important provisions related to the infringement and exceptions, and we shall see the cases in the next video related to the remedies in the trademark.